Hi everyone, my name is Omar. Welcome to my channel, Claims Village. In this video, I will talk about life cycle of the delay events from beginning to end. Before starting, let us to know the definition of the life cycle in general. The definition of the life cycle is the series of the stage through which a living thing passes from the beginning of its life until its death. So, if we could like to apply the same to delay events, we could say that the delay event life cycle is the series of stages through which a delay event passes from the beginning of its life until its resolution. Here, I will illustrate the process of dealing with a delay event from its start to its resolution. The first step in this cycle is the establishment of a baseline program. The contractor should prepare and the engineer should accept a properly prepared program showing the manner and sequence in which the contractor plans to carry out the work. It is recommended that parties agree in the contract a fixed time period for the contractor's submission of the baseline program for acceptance. This should be a reasonable time after the contract award or the commencement date. Pursuant to FIDIC Red Book 2017, the contractor shall submit an initial program for the execution of the work to the engineer within 28 days after receiving the notice under subclause 8.1 commencement of work. After commencement of the project, the baseline program should be updated to record actual progress. The contractor should enter the actual progress on the baseline program as it proceeds with the works to create the updated programs. Now the stage of identification of the deviation from the baseline program. The deviation could occur due to an event or cause of delay, which may be either an employer risk event or a contractor risk event. After that, the stage of discovering of a delay event. When documenting a project's history, the causes of delays can be identified and measured from the updated programs, and this information can be used to support both forensic delay analysis and negotiation. The contractor should consider whether or not the claimed event or cause of delay is in fact one in respect of which the employer has assumed risk and responsibility. That is called an employer risk event. Then the stage of carrying out delay analysis. After proving in the previous step the employer had liability of this event and that liability is breached, then the contractor should prove by delay analysis that breach caused harm in terms of cost and or time. In principle, the contractor will potentially be entitled to an extension of time only for those events or employer's causes listed in the contract as being at the risk as to time that impact the critical path. After that, the stage of submission of delay claim report by the contractor. Application for an extension of time should be made and dealt with as close in time as possible to the delay event that gives rise to the application. SCL Protocol 2017 recommends that do not wait and see regarding impact of delay events, in other words, comprehensive analysis. The contractor should attempt so far as possible to deal with the time impact of employer risk event as the work proceeds. All the standard forms of contract contain obligations on the part of the contractor to give notice to the engineer as soon as an employer risk event occurs. that the contractor considers entitles it to an extension of time. Then, the stage of the assessment of the delay claim report by the engineer. Extension of time entitlement should be assessed by the engineer within a reasonable time after submission of an extension of time application by the contractor. SCL Protocol 2017 recommends that do not wait and see regarding impact of delay impact. Each extension of time application should be assessed as soon as possible and in any event not later than 1 month after the application has been received by the engineer. The engineer shall make a fair determination of the matter or claim in accordance with the contract, taking due regard of all relevant circumstances. When granting or refusing an extension of time, the engineer should provide sufficient information to allow the contractor to understand the reasons for the decisions. After that, the crucial issue is the consultation stage to reach an agreement between the contractor and the employer of the extension of time entitlement. The engineer shall consult with both parties jointly and or separately and shall encourage discussion between the parties in an endeavor to reach agreement. Now the final stage. After consultation and if the parties succeed in solving the issues of the claim by an agreement, then the contractor should revise the baseline program. Reference to SCL Protocol 2017, the revised baseline program shall be revised within 10 working days of the grant by the employer of an extension of time. Each revision to the program shall be submitted to the engineer for its review and acceptance. Once a revised program is accepted by the engineer, it replaces the previously approved baseline program. This is the complete life cycle in a normal procedure from starting the delay events to its resolution. However, if the contractor and the employer fail to reach an agreement for settling the dispute in normal procedure, in this case, the issue should be raised to another level or go to another route. There are a lot of reasons which prevents people solving the dispute by negotiation. The leading causes of dispute observed in 2021 globally according to Arcadis report were first, poorly drafted or incomplete and unsubstantiated claims, error and or omissions in the contract documents, owner contractor subcontractor failing to understand and or comply with its contractual obligations, owner directed changes. So as explained before, if no agreement could be reached in normal procedure, steps should be taken by either party to have the dispute or difference resolved in accordance with the contract dispute resolution provisions. I will illustrate the steps which are adopted by FIDIC Contract Trade Book 2017. Pursuant to FIDIC, that if no agreement is achieved within the time limit, the engineer shall immediately proceed as specified under subclause of engineer's determination. So we could call this stage engineer's determination. When carrying out his duties under this subclause, the engineer shall act neutrally between the parties and shall not be deemed to act for the employer. The engineer determination process shall take approximately from 2 to 3 months. So, if either party is dissatisfied with a determination of the engineer, the issue shall be raised to another level for resolution. This stage, we could call it DAAB stage. Either party may proceed under subclause of obtaining dispute avoidance adjudication board decision. Dispute avoidance adjudication board decision process shall take from 4 to 6 months. So, if either party is dissatisfied With a determination of the engineer, the issue shall be raised to another level for resolution. The another level, or in other words, the final stage, is the arbitration. The arbitration award is binding on the two parties and cannot be appealed, putting into consideration that the arbitration process very long and take from 18 to 36 months. Also, it is costly and sometimes that its fees exceeds the disputed amount in case of a complicated case. It is pertinent to highlight here that arbitration is a very useful tool for resolving disputes, but careful consideration has to be given as to whether it is applicable to or preferable in a particular disputes. Conclusion: delay claims as a very effective way to spend money and divert management resource from running a business. Resolution by way of a mutually acceptable extension of time should be sought at the earliest opportunity to avoid disputes stepping up to the next, more formal process. There are many pitfalls on the path to a successful delay claim resolution, as well as the steps that can be taken to improve the outcome. For example, the contracting party could agree the delay impact comprehensively as they arise during the course of the project's works, rather than adopting a wait and see approach. Effective communication of sophisticated delay analysis require quality in the presentation. There are many ways to present similar facts with different conclusions. Thanks and see you in my next video.